We're going to talk about attorney-client privilege and work product privilege. And this is the material that we would have covered in class on Tuesday night had we had class. And this is also the material that will help you be prepared to do the discussion board that opens on March 14th. So please make sure that you listen all the way through because it will make the discussion board, I think, easier for you. Okay, so starting with attorney-client privilege. So first, we're going to define it. And we talk about attorney-client privilege and work product privilege in all the classes, but we do spend more time and go more in depth in this class. So please make sure you understand it and can define it. So attorney-client privilege and confidentiality are not the same thing. And that's the first thing I want to caution you about. A lot of times we tend to use those terms interchangeably, like they mean the same thing, but they don't mean the same thing. Confidentiality is our ethical obligation. Everything we know about a client from any source, and doesn't matter how we learned about it, when we learned about it, where we learned about it, it is considered confidential. Attorney-client privilege and any other privilege are much more narrow, and they're based in the rules of evidence. So it basically is setting the boundaries of what is not discoverable or what we cannot be compelled to testify in court about. And so these are very narrow, specific rules. So the attorney-client privilege will attach to any communication that meets these three requirements. It has to be direct communication between the attorney or paralegal and the client. So direct communication, it could be face-to-face, it could be in an email, a text, a phone call, a voicemail message, but it has to be direct communication. If someone else is relaying the information to us, then it is not protected by attorney-client privilege. So it needs to be direct communication. Also has to be made in a confidential setting. So this is why it's so important when the client is with us in our office that we are discussing their case with them in an office with a closed door or the library or a conference room, wherever it is set up for us to meet with clients. We should not be having conversations with them about their case in the hallway, in the waiting room, by the elevator, by the front door, at lunch or wherever we happen to see them. So it needs to be in a confidential setting. And keep in mind, we have to take reasonable precautions to ensure it is a confidential setting. We don't have to have a soundproof room, but we need to try to, the firm should be making sure that the room where you're meeting clients is not right next to the waiting area where people can hear you. So we need to just be reasonable about it. Also, sometimes we're having conversations with our client in public, like in the courthouse. And so if you've ever been to a courthouse, you'll have noticed, people huddling in corners and stairwells talking to their client. That can be a confidential setting. So it does not have to be necessarily in a room with a shut. Okay, I apologize again for the barking dog. I have now put the offender outside, so it should be quiet for at least a few minutes. So I do apologize. So it does not necessarily have to be a room with a shut door. If we're in our office, that's what we want to be our confidential setting. But there are times when we are with our clients attending trial, attending hearings, and so we do what we can to try to ensure that is a confidential setting. And the third requirement that has to be met is this communication that's taking place in a confidential setting has to be about the case at hand, has to be about the case in which we are currently representing the client. So if a client comes into our office and starts talking about a completely different legal matter, one in which we're not representing them, one in which they're not telling us about the case so we can represent them, it's not an initial intake or interview on the case, then that does not fall under privilege. And if we were asked to testify about that communication, we would have to do so. So it has to be about the case in which we're currently representing them. And you need all three of those requirements to be met in order for attorney-client privilege to attach to those communications. So that's the definition. So again, important that you do understand that. So some other details regarding attorney-client privilege. So first, privilege is indefinite, which means once the privilege attaches, it attaches to those communications forever. We are never allowed to relay any of that information that the client told us. So once the case is over, it's still protected by privilege. Client dies, it's still protected by privilege. There can always be some, small exceptions to this, but that is the rule. So as far as we're concerned, if the information is privileged, it's also privilege. This is very similar to confidentiality. If it's confidential, it's always confidential, and it does not matter when the representation ends, how it ends, or anything like that. It is always going to be protected. So another thing that's very unique about privilege, different from confidentiality, is that privilege can be waived. Confidentiality technically isn't waived. As far as we're concerned, everything we know is confidential, and it doesn't matter what else happens. As far as we're concerned, it's still confidential. Privilege, though, is a little bit different. And so first thing to always keep in mind is that the privilege is held or owned by the client. And so the client is the only one that can make the decision to waive privilege, meaning to let us share communications that are otherwise protected. However, it is our responsibility as the attorney or the paralegal in the case to ensure that the client is aware of privilege. So it's theirs, they hold it, they make all the decisions about it, but we have to make sure they understand what it is. And so we do that in representation a variety of ways. We ask them not to discuss their case with anyone else. We advise them that we must speak to them alone about their case, and we just explain that if someone else is sitting in on the conversation, if they share the information with someone else, privilege can be lost, and those communications could be discovered by the other side. So we advise clients of that throughout the representation, usually, but especially at the beginning. And if a client would ever want us to break privilege, we would explain to them what it is and the fact that it is their decision, but also make sure they understand the ramifications of it. Privilege can be waived in two basic ways. The first one would be the explicit or express waiver. This is where the client would sign a document waiving privilege. So this is probably the one you don't see very often, if ever. And this would, be a document that would state specifically what information they're waiving privilege to. So if we just have a blanket waiver of privilege, chances are courts are not going to uphold that, because courts are going to construe these waivers in the client's favor, not in the attorney's favor. So they have to be very specific about the fact that this communication is being waived and what communication is being waived. And it has to be very clear that the client understands that it is privileged information, that they don't have to release it. And again, the details have to be there in the actual waiver that they are signing. If there is ever a dispute over this waiver, it will usually not go in the attorney's favor, because these waivers are going to be construed in favor of the client. What you are more likely to see is the implicit or implied waiver. And so this would be a waiver based on the client's conduct. So it's not the client coming to us and saying, I'm waiving privilege, but they take certain action that would waive it. There are basically three ways that we tend to see this. So first one, if the client was to file a disciplinary complaint or file any sort of legal action against the attorney would be able to waive privilege. Let me rephrase that. The client would be waiving privilege insofar as the attorney has the right to defend him or herself. It does not mean that the attorney can release all privileged information, but can only release privileged information to defend him or herself in that disciplinary complaint or legal malpractice action. So that would be the first type of waiver, first way that a waiver would occur. Second one, and this is the one that probably happens more than any other, is when a client repeats privileged information to third parties, meaning somebody that's not working in our law firm. That is an implied waiver as to those communications. So that is why we typically advise clients not to discuss their case and our conversations with them to other people. Although in many cases it is unlikely that opposing party would find out that client actually disclosed privileged information. If they do find that out, then we could be compelled to testify to that particular conversation. And that would be discoverable, or we could be called as a witness at trial. So we don't want that to happen. And in certain areas, that is a huge thing in family law, for instance, because frequently both parties know each other's friends and family. And so when one goes home and tells a friend or family member something, it frequently works its way back to, to someone on the other side. And I never had a situation where I had to deal with an implied waiver of privilege, but it's definitely something that we want to take reasonable steps to try to avoid. But that's why we advise clients to not share our discussions with other people. And the third way we tend to see an implicit or implied waiver is if the client fails to pay attorney fees, and then the attorney has to file an action against the client to recover those fees. The attorney is able to release information necessary to demonstrate the amount of work that was done and to prove their case for attorney fees. So in any of these situations, any of these three implied waiver situations, the information that has been waived is only what is necessary to defend yourself against a complaint, to pursue an attorney fee claim, or the information that was specifically released by the client to the third party. So even when you have the privilege being waived, it's still going to be limited to those specific situations. It's not going to open up everything and allow everything to be discovered or released. So, so they're very particular, very focused waivers if they do occur. Okay, some additional information about privilege. Privilege attaches to communications even if the attorney does not ultimately represent client. So this means when a client comes in for that initial consultation with an attorney, and then either the attorney doesn't take the case or the client doesn't want to hire the attorney, privilege still attaches to those communications. So the ethical rules are very clear about this. And so a client does not have to worry about the fact that they shared information with an attorney and then they don't hire them, that information somehow can be released. It cannot. So, so privilege, not only is it indefinite on the one end of the representation, it attaches even if a formal client-attorney retainer agreement is not entered into. Privilege extends to agents of the attorney, so of course to paralegals, but to secretaries or anybody else in the firm who has any contact with that client, that would be protected. Those communications would be protected by privilege. And there's a typo, I apologize. An eavesdropper does not destroy privilege. So again, as long as we take reasonable precautions to have a confidential setting, we have protected privilege. So, if you have someone intentionally trying to listen in, then it's not going to have any effect on privilege. It has not been waived in any way, shape, or form. So, so that is some of the generalities about privilege. So the question then is, what would not be covered by attorney-client privilege? And this can depend on state law. There can be some differences from state to state, but generally this information is not protected by privilege. So identity of client. So generally, whether or not a client is, someone is a client of yours, is generally not protected by privilege. Now, again, we're talking privilege. Confidentiality is a little bit different. If somebody calls our office and says, are you representing so-and-so, or if they contacted you, confidentiality would not allow us to release that information. And so again, the rules are a little bit different. Confidentiality is much broader. Attorney-client privilege is much more narrow. So usually identity of clients is not protected by privilege. There could be some exceptions, but generally that's the rule. Location of clients also generally not protected by privilege. Now, again, some exceptions. One would be under the protection from abuse law. There is a provision where the location of a party can be kept confidential and not be released. So there, again, are some exceptions that usually are related